Yes, Mr. Mills.
Comparison.
Yes.
We were on paragraph 97, my lord, of the EAT's judgment.
Yes.
This is in the context of whether post-termination, just to recap, post-termination whistleblowing was within the scope of the ERA. Court of Appeal case, Fadit said no. After that, Rees-Harper decided by House of Laws to say that post-employment victimisation was within the scope of the then RRA. And the question for Lord Justice Ward and Lord Justice Morris Kay and Woodward was whether that could be read across or whether the doctrine of precedent precluded it. The Court of Appeal concluded that it could, for the reasons which are essentially summarised at paragraph 59 of that judgment, considered by 97 of Justice Cavanagh's judgment. Although the language and the framework might be slightly different, it seems to me that the four acts, the PIDA, SDA, RRA, DDA, are dealing with the same concept, namely protecting the employee from detriment being done to him in retaliation for his sex, race, disability, or whistleblowing. All four acts, therefore, are dealing with victimisation of one form or another. The common theme is victimisation. It would be odd indeed if the same sort of act could be victimisation for one purpose but not the other. Similarly, in relation to strikeout, judgment of this court in Asias, same principles apply because there's an analogous public interest consideration. Paragraph 31 of Asias inserted here at 99. And Osipov, which I'll spend, conscious of time, but I will spend a couple of moments on in a moment. And ultimately, where that took Mr. Justice Cavanagh is paragraph 112. That there were specific features comparing strictly 103A of the ERA and Section 39 of the Equality Act, the limitation provisions and injury to feelings, which meant that they were not, the domestic measure was not more favourable. But important to note, paragraph 128, conclusion and summary on equivalence, I've not found this issue to be an easy one. So whilst the equivalence argument failed, it failed by a margin, it would appear. What the Secretary of State says here, paragraph 38, page 65, for your note, I don't propose to take you there, is that it's not possible to compare the two regimes because they're not in an analogous situation, reference to Kuzal, etc. But here's the rub. Statutory provisions do not experience Article 14 discrimination. People do. By that I mean this. Compare the dismissed whistleblower with the dismissed victim of discrimination. And what Osipov makes clear is that the dismissed whistleblower is not confined to a 103A claim. They can pursue a claim under Section 47B. Osipov, we have tab 47. Forgive me, 46. And the issue in brief was this. Individual dismissed by a company which ultimately goes into administration, therefore no assets. Could the claimant pursue a dismissal as detriment claim?
Sorry, yeah.
Could the claimant pursue a dismissal as a detriment claim under Section 47 against the two individuals who were good for the money? And the ET, the EAT, and the Court of Appeal all concluded that that was possible because the effect of Section 47B and the incorporation of the vicarious liability provisions in 47B made it clear that the principles governing the Equality Act applied to just the same extent as they did to the ERA. In other words, you could pursue a dismissal claim against the two individuals and therefore recover post-termination losses. And the point was made by those individuals that would drive a coach and horses through the carefully curtailed provisions of automatic unfair dismissal under section 103A. Paragraph 64 of the judgment, summarising the submissions of Mr. Stillett. If the claimant's construction of section 47 was accepted, it would undermine the careful demarcation between Part 5 detriment, Part 10 dismissal. In practice, in every case of whistleblower dismissal, the claimant would proceed against the employer under section 47B(1)(b), as well as or instead of under section 103A. Two specific advantages identified: the award of injury to feelings and a less restrictive test of causation. Both of those were considered, but not regarded as decisive. Paragraph 69 of Lord Justice Underhill's judgment. I would add that if Mr. Stillett were right, the scheme of protection for whistleblowers will be less effective than for victims of other kinds of discrimination and victimisation at work. As noted at paragraph 33 above, under the 2010 Act, dismissal is simply another form of detriment for which the employer and any responsible co-workers are potentially liable, then to commonly brought against individuals as well as employers. There's a limit to the extent to which it's possible to assimilate, but the two situations are nevertheless essentially similar, and other things being equal, one would expect Parliament to have intended to follow the same substantive approach in each. And as a consequence of that, we see at paragraph 73 that an individual may bring a whistleblowing dismissal as detriment claim and recover injury to feelings. Paragraph 73, Lord Justice Underhill said this: in any event, these anomalies, intentional or not, are only of significance if they suggest that there was a positive statutory intention that no claim could be advanced under section 47B at the detriment to the form of dismissal, even if it could not be advanced under section 103. I do not believe that they do. I would add, as regards compensation for injury to feelings, that but for the mismatch with Dunarky, there's nothing surprising about such compensation being available in a case where the detriment takes the form of dismissal. It's always been understood to be available for detriments other than dismissal, and it's also available in the case of discriminatory dismissals under the 2010 Act. It might even have been thought that the real anomaly was that it's not available under section 103A. Take a step back, as Article 14 requires. The dismissed whistleblower. Lower causal threshold under section 47B, injury to feelings awarded under section 47B, may also pursue an interim relief application under 103A. Same cause of action, dismissal, same wrong, but has two tools at their disposal. The dismissed victim of discrimination Equality Act discrimination does not, despite the fact that, as Lord Justice Underhill recognised in Osipov, all things being equal, one would expect the same provisions to apply to both. And that's the comparison. Now, what does the Secretary of State say about this? Two things. Paragraph 60, page 65, paragraph 40 of the core bundle. At least two reasons, paragraph 39 says why it's sufficiently clear, not in an analogous situation. And this plays into the arguments on justification and purpose of construction as well. First, Parliament's decided by way of section 103A to confer special protection on whistleblowers and do so in the public interest.
Sorry, yet again, I'm behind him.
Apologies,
Mr. Milson,
my
where
We're-
are we on?
We're on page 65 of the core bundle, tab 5, paragraphs 39 through to 40.
Paragraph
39.
Yes, thank you.
And then a friend says this. Special protection for 103A, people who take active steps to raise important concerns. However, save for victimisation, paragraph 41, none of the claims under the 2010 Act concern employees being subject to detriment because of their actions at all. Just think that through for a moment. The distinction seems to be doing something first and then potentially doing something in the public interest. As for doing something versus nothing at all, that distinction was raised by Mr. Justice Cavanagh of his own volition in the paragraph I took you to earlier, and rightly discounted. And it doesn't stand up to scrutiny. Consider the individual who notifies their employer of their pregnancy, or their sexual orientation, or their disability, or their proposed gender reassignment. Consider the individual who rejects unwanted sexual advances. They are doing something. And they are doing something which it is recognised as in the public interest that they should not be subjected to reprisals for. That's why all the authorities, Isaias, Osipov, etc., make the point that they are all anti-discrimination statutes. But what are the protected characteristics?
Depends what you mean by discrimination, doesn't it?
Melody,
Because apart from victimisation, which is different, discrimination entails or implies some sort of comparison, doesn't it?
well, comparison in what sense? The fundamental question is, of course, is somebody being treated less favourably because of their characteristic,
Yeah.
which entails often, but not by no means universally, after Shamoon, the consideration of an actual or hypothetical comparator. But in the direct discrimination context, an employer requires knowledge. And in a changing protected characteristic, that knowledge is typically brought to the attention of the employer by the employee in question, informing of a diagnosis of a disabling condition, informing of sexual orientation, whatever it might be. But an individual clearly does something in many of those circumstances. I'm going on maternity leave, I'm pregnant, etc., which engages the public as Lord Justice Morris Kay accepted in Isaias. But if we have a circumstance where an individual doesn't do something, doesn't inform of a change of circumstance which engages the Equality Act, doesn't reject unwanted advances for the purpose of Section 26 of the Equality Act. Rather more typically then, if it's not about doing something, it's about protected characteristics which are immutable. Discrimination on the grounds of sex, discrimination on the grounds of race. Now, the distinction my learned friend seeks to draw turns the conventional principles of discrimination on their head. Because what has been typically understood is that those characteristics which are immutable, whether it's an immutable characteristic that somebody cannot or cannot sensibly be expected to change, which is the reason for the adverse treatment, that's the core of Lord Walker's concentric circles, requiring particularly anxious scrutiny.
Doesn't it depend in part, at least, on the reason why the discrimination is considered to be inimical to the public interest or inimical to human rights? Because let's take defamation. People get treated less well than others because someone has said something disparaging about them, which may or may not be true, but it can be argued that fundamentally the objection to, or the reason for protection against defamation is to protect people against being treated in a discriminatory way, but nothing to do with any characteristic, but because of some statement, that some conduct that's been attributed to them, or some characteristic.
Yes.
That's way outside the sphere that you're looking at.
Well, it's way outside the sphere of the Equality Act.
Yes, quite. But it still can be analysed as discrimination. Within this sphere, you might say, well, the reason why discrimination against people who are whistleblowers is protected by Parliament is a distinct reason, okay, distinct category of reason, from the reason why people are protected against discrimination on the grounds of one of the protected characteristics.
Well, my lord, the first point I'd make on that is that whistleblowing, one takes a look at the international perspective for a moment, is a comparatively new kid on the block. There's an EU whistleblowing directive which is relatively recent and confined in its scope. Compare that to the council directives from 76 onwards, the Sex Discrimination Act of 75, the Race Relations Act of 76. Whistleblowing is typically seen as more fundamental a basis of discrimination as the characteristics which form the focus of the
I think that was my
Equality Act.
point, but it's not about how fundamental it is, or whether you can say this is just as bad as that, or this is at least as bad as that, but about different types of reason for prohibiting the discrimination. So your point really chimes with what when sex discrimination and race discrimination were being recognised in domestic law, whistleblowing wasn't, because it wasn't considered at that time to be on a par.
Yes.
But the fact that it's not on a par, or may not be on a par, isn't necessarily an answer.
Well, the reality of the situation in my submission is this. It is the historic genesis of anti-discrimination in the Equality Act sense, sex, race, etc., is more long-standing, is more a matter of international consensus, and as the Supreme Court and House of Lords have consistently recognised, is at the heart of what anti-discrimination measures worldwide, and particularly in relation to Article 14, are about. And the reality of the situation is that the whistleblowing started as a domestic measure, which has been improved upon in terms of measures of protection incrementally by way of the introduction of vicarious liability. And we're now in a situation where the whistleblower is better protected than the victim of sex discrimination, race discrimination, etc. in that, as a matter of the employment tribunal context, they can get their uncapped damages, and they can get their uncapped damages on the basis of a generous burden of proof, as a Section 47B dismissal claim. They can get their injury to feelings, and they can also get interim relief. And despite the best efforts of my learned friend, who seeks to persuade you that there was a conscious decision to treat whistleblowing more favourably in that respect than Equality Act dismissals, that's not how it's worked. What's happened is that there's been a series of incremental steps to improve the protection of whistleblowers, but Parliament has not taken stock of the fact that there is now a better set of protection for the whistleblower than there is for the victim of orthodox discrimination.
No, we should take it for them.
Sorry?
We should take it for them.
What you have to do, my lord, is do what Parliament intended by way of Section 3 of the Human Rights Act, which is to confer construe legislation insofar as possible to do so.
Well, it can't. I mean,
In,
well, I know
insofar
we're
as-
coming to this, Mr. Milton. It can't possibly be construed in the way you say. It's got to be on the basis of that if you win, then the law as it stands is incompatible. The statute which says you can have interim relief for trade union activity and health and safety and so on, and you can have it for whistleblowing. You can't say it can be interpreted as meaning, and you can have it for all Equality Act claims, dismissal claims as well. It's got to be. It seems to me it's incompatibility or bust, really.
Well, for reasons that are inevitable, I will seek to persuade you otherwise.
Yes.
But
All right.
I see the challenge I must meet.
I mean, the Public Interest Disclosure Act was, as you reminded us, originally a private members bill dealing with a specific topic. But you're saying that as from the enactment and coming into force of Section 3 of the Human Rights Act, 2000, there has been an unlawful discrimination between the protection given to whistleblowers and the protection given to all Equality Act claimants, or what are now Equality Act claimants.
Yes.
Or formerly SDA, RRA, DDA, and so
Yes.
on.
Yep. Exactly the same.
Okay.
In terms of the doing something point, I'm conscious of time, but can I just flag Carson at tab 20, paragraphs 55 to 59. I don't propose, if I could just put these on your list of reading material, as it were, rather than turning them to because I am conscious of time. And AL Serbia, tab 24, paragraphs 27 to 30. There, Lord Walker and Baroness Hale, respectively, make the point that those characteristics which someone cannot or cannot be expected to change are of a different category. And we say that those are the categories, those are the characteristics with which the Equality Act is principally engaged.
Yes.
I'll turn to justification,
Yes.
which is, of course, were it not for the Secretary of State's intervention, where I should have started about 11 o'clock this morning.
Yes. Yes.
Firstly, well-established principle, it's the discriminatory effect of the measure which must be justified and not the measure itself. We get that from Baroness Hale, again AL Serbia, tab 24, paragraph 38. As to the test of proportionality or the test of justification, you have three options. Core status, i.e. the true state Article 14 status is a core status as recognised by the Equality Act. We know from Jurjic and Boyraz and LB, very weighty reasons, heightened scrutiny, etc. And the reason I say that is because on true analysis, going back to my submissions this morning, the real characteristic in issue is the reason for which someone's dismissed, and that's a core. Those reasons across the board of the Equality Act are core reasons. The second option you have is the ordinary proportionality test. And the third, which is urged upon you by the Secretary of State, is the manifestly without reasonable foundation test. As to the latter, the invitation to accept the latter, we say, is a non-starter, following Gillen in the Supreme Court. And that's tab 44. Paragraph 34. Where the Ministry of Justice sought to argue that the scope of the Employment Rights Act was a matter of social policy and that the correct justification test was manifestly without reasonable foundation. That was rejected by the Supreme Court. While it's well established, paragraph 34, that the courts will not hold a difference in treatment in the field of socio-economic policy unjustifiable unless it's manifestly without reasonable foundation. all the cases which that concerns relate to the welfare benefit system. It's also in that context that the test has been articulated by the European Court. This case is not in that category, but rather in the category of social or employment policy, where the courts have not always adopted that test. So you have from the Supreme Court clarity that the manifestly without reasonable foundation test does not apply in the field of employment legislation. This is not a welfare, social security, allocation of resources case. As I say, on proper analysis of what the true status is, or if one's to adopt the analysis of Mr. Justice Cavanagh, that given the fundamental rights in issue, it's a heightened justification test, then we say very weighty reasons are needed. The middle ground, it would seem, is the test as set out by Bank Mellet, ordinary proportionality test. Firstly, that the objective of the measure is sufficiently important to justify discrimination. Secondly, that it's rationally connected to the objective. Thirdly, whether a less intrusive measure could have been used without unacceptably compromising the right. Or finally, whether balancing the severity of the measure's effects, the former outweighs the latter. And this is in the context of some of the points that I've taken you through, the questions of delay, enforcement, a heightened effect of loss of employment on protected classes. And of course, the burden of justification rests with the Secretary of State. Now, before turning to the aims which are identified, I just want to make two quick points. The first is that the United Kingdom is an outlier when in not extending or in confining losses to discriminatory dismissals to compensation. You have the ILO report and a comparative study of European jurisdictions. By way of example, in France, Greece, Ireland, Italy, Lithuania.
Is this written down anywhere?
It is. Well, it was accepted by.
Well, it may be.
It was accepted by Mr. Justice Cavanagh.
I'd still like to see it on the page.
So be it. Tab 73. And the page number is 1968. And it's the sideline passage there.
Sorry, you give the page number again.
1968.
Thank you.
There's various measures, and these are measures in addition to discrimination. But we see, just by the first hole punch, if you're in physical copy, discriminatory acts are null and void, or in some countries voidable. They can be annulled by competent courts. France, Greece, Ireland, Italy, Lithuania, the Netherlands, and Spain. In an island, there's a range of courses of action which include declarations of nullity. Now, I appreciate not the same as interim relief, but nonetheless, the common practice in the European jurisdictions is something in addition to the award of compensation. Secondly, the central question in many of the justification cases is whether there has been a legislative choice, or as it's put in the citation in my learned friend's skeleton at page 67, citation of Lawrence and Fenn Tigers, informed legislative choices. Can I ask you to turn to C, again, that's tab 45, and the judgment of then Justice Leggett, paragraphs 92 to 93. paragraph 9, really the passage from 90 over the page on the question of intensity of review, in which Lord Justice Leggett identifies three particularly important factors. One I've addressed, which is the nature of the ground, and we see the core grounds: race, nationality, gender, religion, sexual orientation, not incidentally whistleblowing. The second relevant consideration, paragraph 92, is whether the measure resulting in differential treatment has been approved by Parliament, and if so, with what degree of scrutiny. G, plainly the weight which should be attached to the democratic basis for the decision is even greater where the measure in question has not merely been considered but been enacted in primary legislation. And then a third important factor, paragraph 93, is whether or to what extent the values or interests relevant to the assessment of proportionality were actually considered when the policy choice was made. Thus, it is clear that where a public authority has addressed a particular issue before the court and has taken account of the relevant human rights considerations in making its decision, a court will be slower to upset the balance which was struck. Conversely, where there is no indication that this has been done, the court's scrutiny is bound to be closer, and the court may have no alternative but to strike the balance for itself, giving due weight to such judgments as were made by the primary decision maker on matters he or it.
But how do you apply that to the history of unfair dismissal legislation? And it is employment tribunals, industrial tribunals didn't exist till the 1960s, and they're brought into effect for tiny little things like redundancy payments and so on. Unfair dismissal introduced in 1971.
Yep.
Industrial Relations Act 1971. Reinstatement, re-engagement or compensation, very limited. No interim relief. 1975, first interim relief for trade union linked dismissals. Then 1996, Public Interest, 1998 Public Interest Disclosure Act. It could be said the original decision by Parliament was to set up industrial tribunals with very limited powers. They can't, for example, grant injunctions. Never have been able to. Then exceptions are made, but you're saying that there was no informed decision by Parliament to reject interim relief in discrimination cases. Nobody suggested it.
Right.
You would say would it be different if somebody had proposed an amendment to one of many employment bills and it had been voted down by the government of the day?
Yes, because on the analysis of Lord Justice Leggett, a deliberative choice would be made there.
But surely Parliament must be taken to know when it enacts a piece of legislation what other legislation it has already enacted. So by enacting the 2010 Act in the form that it did, Parliament made a decision to enact it in that form and not to enact it with the bells and whistles that apply to, for example, dismissals on the grounds of whistleblowing.
I'll take you, when it comes to purpose of construction.
Well, this has got nothing to do with purpose of construction. This
Well,
is to do with your point that Parliament hasn't thought about it.
Well, it clearly legislates against the pre-existing backdrop. That much is a well-established principle of statutory construction. But what Lord Justice Leggett is driving at is that there is a difference between a positive decision being made, where the court should be understandably cautious, and that where no such decision is made. And in Coleman, one of the points that was made by the employer was that there were various stages where it could have been associative disability discrimination could have been included and wasn't. It's quite clear that the focus of the then DDA was upon the protection of disabled people rather than those associated with disabled people. And the point that was made by then Mr. Justice Underhill, was that's not the same as a positive choice. It's not the same as a positive decision. The one thing that we do know is that Parliament, post the passage of the Human Rights Act, intended to legislate in accordance with Section 3. And the point that's made by Mr. Justice Cavanagh is that this challenge...
Sorry, just let me get over that. Parliament intended to legislate in accordance with Section 3
of the Human Rights Act. And so, in the absence of a positive intention to legislate so as to oust the effect of Article 14, it's not enough to presume that a positive choice to exclude interim relief was made. The point that was made by...
Did you mean Section 6 of the HRA? I mean, I think your point is that the legislation must be presumed to have been considered compliant with the Human Rights Act.
Yes.
Yeah, whichever section. And there was probably a declaration of compatibility.
Well, the point is that in passing Section 3 and Section 6 of the Human Rights Act, Parliament intended, and we get this from Claimant, to legislate in accordance with the Human Rights Act, unless it can be clear that a contrary statutory intention is shown, i.e. there's a fundamental feature of a piece of legislation which goes against the grain of that presumption.
Do you say that there was nothing wrong with the jurisdiction given to industrial tribunals in 1971 at the time? But the introduction of the Public Interest Disclosure Act, interim relief, and the enactment of the Human Rights Act means that what was previously acceptable is no longer acceptable and is therefore incompatible.
Quite so, crystallised by the effect of Osipov, which means that a whistleblowing dismissal is now akin to a discriminatory dismissal, with the added pre-existing bonus of being able to pursue an interim relief application where the reason for dismissal is whistleblowing.
Right.
And this is where we turn to the statement of Mr. Ramsden,
Yes.
who provides a statement on behalf of the Secretary of State. And that's at tab 6. He deals with his long-standing experience at paragraph 9, page 75. I was working in the GEO during the later stages of the Equality Bill's formation, about 7 months before the bill was introduced in Parliament and its parliamentary passage. So well placed to comment on any positive decisions passage of the Equality Act. And yet, if we continue to paragraph 14, my team of officials has made efforts to identify contemporaneous evidence of the specific reasons why Parliament chose not to make provision for interim relief. Not been able to identify any such explicit consideration. Nevertheless, it seems obvious from the legislative history that Parliament must have been fully aware that interim relief was to be available in certain circumstances. And then, at the bottom of paragraph 15, accordingly, I believe that it's right to proceed on the basis that Parliament chose not to extend interim relief to discrimination claims. Now, despite the fact that Mr. Ramsden was involved in the 7 months prior to the bill being presented and the parliamentary passage, he does not, and I don't criticise him for it, give any evidence as to this being expressly considered at the time. It's a question of supposition. And the reality of it is, the reason there's no contemporaneous evidence to consider the extension of interim relief is because nobody thought about it, including the Commission, may I hasten to add.
Yes. Yes.
And the reason for that is perhaps obvious. We don't seek to argue that the absence of interim relief is a breach of the substantive convention rights, 6.8 or A1P1. The focus is upon discrimination, Article 14.
Yes.
That requires analogous situations to be treated differently. Now, the situation we're now in, post PETA 98, post Osipov, is that the dismissed whistleblower has the works, injury to feelings, lower causal test, ability to pursue against co-workers, uncapped damages, and interim relief. And the individual dismissed on grounds of pregnancy or sexual orientation does not have the latter.
Yes.
And there's been no moment since Osipov, since the discrimination was crystallised, where Parliament's considered or applied its mind to the issue.
If you're right, I mean, never mind Osipov. We work on the basis that decisions of the courts reveal a hidden truth, as it were. It can't be said to change the law. If you're right, this unlawfulness has existed at least since 2000. Coming
yes.
into effect of
Yes.
both Public Interest Disclosure Act and the Human Rights Act.
Yeah, I accept that must follow.
Yeah. And the Mr. Ramsden writes about Equality Act 2010. It wasn't quite a consolidation act, but it was a sort of harmonisation act, and it to a significant extent reproduces the predecessor acts. Not exactly, and I think what we get from this is nobody thought about whether the status quo in the previous acts needed changing in this respect. Nobody suggested it.
And nobody is to be criticised for that. It just simply hasn't happened. And what it's telling, we say, paragraph 16, bottom of page 77, having now considered the policy rationale for the position, the reality is that Parliament did not consider it beforehand.
Can I just, this is probably a question with a short answer, but how does all this examination of what Parliament did or didn't think or say or do during the passage of the Equality Act square with the Bill of Rights? Because normally we're not entitled to have a look or to sort of draw inferences about what people thought or didn't think, unless there's a good reason to do it, like ambiguity. And it just struck me as rather odd that outside the context of an executive act, where it's quite easy to see how you can scrutinise that we should be invited to make decisions about whether Parliament, collectively or individually in the form of any member of Parliament, was thinking about certain things, such as compatibility with the Human Rights Act.
Well, there are authorities on which my learned friend places particular reliance, Wilson, for example, in which consideration of whether Parliament had applied its mind to the issue necessarily involves consideration of Hansard or matters of that nature, or statements from the presenting minister, for example. Where this goes to is, firstly, the absence of interim relief can't be said to be a cardinal feature of the legislation if nobody applied their minds to it. But nor can justification, the closer scrutiny that Lord Justice Leggett had in mind, is particularly important here, because the decision has not, there's been no positive decision on the issue at all.
Well, I see that. All I'm asking is is it a proper route to reach the conclusion that there hasn't been consideration? Well, that's a step on the route.
It seems to me that
your scrutiny test.
Well, the authority necessarily entails that is permissible. Otherwise, quite how the three important factors that Lord Justice Leggett had in mind could be exercised would be difficult. And indeed, there's.
I can't quite remember what the context was there.
That was the ECHR benefit policy.
Yes.
Or
was that in primary legislation?
Primary legislation, but the question of intention and justification was decided by reference to surrounding material as well.
Anyway, you don't have to go into very controversial Pepper and Hartish territory to everyone's agreed that there were no amendments in the passage of the bill which became the Equality Act 2010, which concerned the question of interim relief. So you don't have to say, did the minister explain this or something? No, nobody explained it. Nobody voted on it. Nobody thought about it.
No, but the secondary issue is it is an unsafe assumption, we say, to presume that Parliament applied its mind to the question of interim relief and decided to count against it. That there's simply no evidence to support that at all. Now, the aims that are relied upon by my learned friend, firstly, protecting and encouraging employees who take specified steps. And as he puts it at paragraph 49.1 of his submissions, the line has to be drawn somewhere. The line clearly has to be drawn somewhere. The question is whether this line is compatible with convention rights. And we say it simply isn't, for the reasons which I've spent some time addressing. Discriminatory dismissals are distinct categories, and they sit rather more comfortably with those which with whistleblowing. In fact, as I say, as I hope I've made clear, whistleblowing has built upon discrimination, and it's now in a better position. It's older sibling. But also, extending interim relief to those subject to a discriminatory dismissal does not deprive those other categories of persons from enjoying that right too. The individual who's dismissed for whistleblowing is not deprived of the right to seek interim relief just because another category of individuals is also protected. So the assertion from a learned friend that extending interim relief would undercut the rationale of Parliament simply makes no sense at all. The second aim that's relied upon is placing additional burdens on employers. Firstly, we say that ignores the difficulties that an application for interim relief faces, the 6 control mechanisms I set out. And it also ignores the fact that as a matter of both EU law at the time of the Equality Act, but also the domestic imperative of the Equality Act on the face of the statutory title itself, the tribunal must give full, effective and dissuasive remedy for a discriminatory tort. It must compensate in full. And so the question of whether that an interim relief order in some way imposes an additional burden simply makes no sense when all it does is restore the individual from the discriminatory wrongdoing of their dismissal. If an order of interim relief is granted, it's been granted because the tribunal has concluded with a high degree of certainty that the claim will succeed and the individual has been deprived of their earnings on a discriminatory basis. The point's made that the losses may be irrecoverable. Firstly, with the exception of Robinson, at no stage, and certainly my knowledge of the 46 years of interim relief being on the books, has there been a case where the claim ultimately fails at trial when an interim relief order has been granted? And secondly, why is that burden acceptable for the reasons already identified by Parliament, but not for an Equality Act dismissal? It's suggested that there are longer and more complex hearings. Well, the answer is the face of the rules of procedure themselves, i.e. that no oral evidence is, save in exceptional circumstances, heard. And the other point that my learned friend makes, page 69, paragraph 49.6, is that only 3% of sex discrimination claims succeed. That risks being a little misleading, because if we look at page 117 of the core bundle, it's very small writing, but the 3% is the total of claims that are presented. 3% of those presented succeed, 6% fail. In other words, only 9% make their way to a full hearing, of which a third succeed.
Yes.
So the suggestion that only 3% of sex discrimination claims succeed needs to be understood in its context. Only 3% of those ever presented, and a third of those succeed. The other point I'd make just looking at this table is this. In 2007, 16,184 sex discrimination claims presented. And the tribunal was required to do that which EU commanded, provide full, effective, dissuasive sanctions, timely remedies, etc. That number has almost quartered. Now, 2019 to 20, 4,472 claims. So a quarter of those presented in 2007 per annum. Sex discrimination claims have slashed by 75%.
One, I don't know whether this is relevant. Two, there may be false statistics because I was involved with one of the hearings in Asda and Warby, which concerned applications by multiple claimants. If you have a claim for, particularly for equal pay, brought by, as some of them were, by 1,200 claimants, whether you count that as 1 or 1,200 has a tremendous effect. Anyway, let's not spend too much time on the statistics. If there are any statistics you particularly want us to focus on, I'd be ever so grateful if they were produced somewhere in legible font, because the pull-out chart is really not much.
It's close to indecipherable. The reason I flag that issue is that another aspect of the justification and the purpose of construction point that is made is what about the poor tribunal deluged, etc. What these statistics show is a drop of some 100,000 claims presented in over a 10-year period. Dropped off considerably during the fees regime has not actually picked up to its 2007 levels. And so when considering questions of floodgates and tribunals being overwhelmed, particular caution is required in circumstances where actually the number of claims in issue is considerably less than that which had to be serviced by the tribunal previously. And there's simply no material to suggest that the tribunal is going to be swamped with interim relief applications. Indeed, this turns to the other point which my learned friend makes, 15.6 of his submissions. Forgive me, 49.8, apologies, 15.6 is in relation to Mr. Ramsden's statement, which obviously covers similar ground. 49.8, page 69. There's no evidence to suggest the availability of interim relief would either result in fewer claims being withdrawn or promote fair settlements. Claims are withdrawn for a wide variety of reasons. Further extending interim relief may have an adverse effect on withdrawals and settlements. At the very least, it cuts both ways. Most interim relief applications are unsuccessful. In such circumstances, they will increase expense and stress for claimants that the risk of withdrawal will be higher. So, essentially, what the Secretary of State puts forward is material which at best cuts both ways. And then when we come to Mr. Ramsden's statement, page 80, 15.6, it said that conversely there's no evidence to suggest that the availability of interim relief would either result in fewer claims being withdrawn or promote fair settlements. And in the very next paragraph, 15.7, cases where interim relief was refused could result in withdrawal, irrespective of the merits of the case. So it's difficult to know what this court is, on any proportionality test, supposed to do with that material, where it's essentially little more than equivocal speculation, which is in itself internally contradictory. truth of it is, nobody's applied their mind to it, and there's simply nothing before you to support the wholesale exclusion of any guise of interim relief for any guise of discriminatory dismissal. A further aim identified is the maintenance of a relatively simple and consistent approach to remedies. That would strike many an employment practitioner with some surprise, given the complex issues that remedies already raise, as to pension calculations, equal pay calculations, apportionment, causation of damage for personal or psychiatric injury. Compared to that, the availability of interim relief is rather more straightforward, because all it does is continue the status quo. It holds the ring until a claim is determined or resolved. It's also suggested that there's complex questions raised in discrimination complaints. No more complex than the question of whether a protected disclosure has been made, worker status, illegality in Al-Qasimi or Tarberg respectively, or the question of whether there's union activity, etc. And then finally, the point that is made is maintenance of an effective and efficient tribunal system for all litigants. The reality of it is that since Parliament has not applied its mind to the likelihood of any question of number of interim relief applications, in circumstances where there's only 119 pursued every year as it stands, and across the board of the Equality Act, protected characteristics will produce a more legible version of the Secretary of State's numbers. Across the board between 2007 and 2019, it's not just sex discrimination, every protected characteristic has shrunk considerably in that period of time. The evidence of deluge is lacking. It is, of course, true that the pandemic has had a particular impact. But of course, the discrimination existed long before this could be sensibly predicted.
Yeah.
And in any event, the tribunal system is very much turning a corner. Remote justice has been working effectively. The backlog has cleared considerably. And given the importance of this issue, it would be improper, in my submission, to decide it on a once and for all basis on something which is not predicted at the time the discrimination that came into effect and is in the process of being cured. The one thing perhaps worthy of note is that as it stands, the President of the Employment Tribunal continues to, of both England, Wales and Scotland, continue to see a role for remote hearings. Interim relief hearings are one such hearing where that has worked in personal experience and can continue to work precisely because no evidence is being heard. So we say applying the factors of Lord Justice Leggett, this is a core status territory or closely akin to core status. Parliament's not applied its mind to it. The value judgments which are necessary have not taken effect. And the material which is now adduced does not begin to justify the wholesale exclusion of interim relief. That leaves, and so therefore there is unjustified Article 14 discrimination. What to do with that? There are two options. Declaration of incompatibility, which the Secretary of State does not resist if you're with me on everything that I've said so far. So it's not being suggested that if there's no Section 33 reading that's possible, a declaration should not be made by the Secretary of State. But we say this is a case in which Section 3 can apply. Coleman, at tab 30, well-known authority, obviously, and I won't spend too long on the facts. Essentially, the question being whether the failure to extend direct discrimination to those associated with disabled people it was compatible with the directive. It's trite law that the leasing approach is the same territory as Section 3. There's some suggestion that Section 3 is wider than leasing, but I don't propose to spend too long on that. Paragraph 12 of Coleman starts with what Lord Nichols said on Gaydon, which, let's see if I may say it rather more succinctly, what I was hoping to submit to my lady, Lady Justice Laing. Paragraph 26 of Lord Nichols. Section 3 is a key section of the Human Rights Act. It's one of the primary means by which convention rights are brought into the law of this country. Parliament has decreed that all legislation existing in future shall be interpreted in a particular way. All legislation must be read and given effect to in a way which is compatible with convention rights, so far as it is possible to do so. This is the intention of Parliament expressed in Section 3, and the courts must give effect to that intention. That is a broad section, and if we go to page 653 of the Authorities Bundle, citation from Lord Nichols again, here's paragraph 32 by C. In other words, the intention of Parliament in enacting Section 3 was that to an extent bounded only by what is possible, a court can modify the meaning and hence the effect of primary and secondary legislation. And if we go to paragraph 13 of Coleman, there's the summary of the position so far as possible. Former Justice Underhill continues at paragraph 14 to accept the reality of what's going on here. In Gaydon, the question, of course, was whether the Rent Act extended to same-sex couples, and as he rightly recognises, just by letter D, that was plainly not the intention of Parliament when the Act was enacted, nor does it correspond to the actual meaning of the words, however liberally construed. The implication was necessary in order to give effect to convention rights, and it went with the grain of the legislation. In my view, the situation with which I'm concerned is closely analogous. The prescription of associative discrimination is an extension of the scope of the legislation as enacted, but it is in no sense repugnant to it. The point was made by counsel for the employer, paragraphs 18 to 19, that this clearly went beyond what Parliament in fact intended. As to which Mr. Justice Underhill said this, the section from B. In one sense, it is indeed true that the disabled status of the putative victim is a fundamental feature of the 1995 Act. The whole Act is, as Mr. Solomon emphasised, drafted on that basis. But in another sense, it is not true. It could equally be said that the fundamental feature of the Act was the prescription of discrimination on the ground of disability. And then continues by E. The kind of exercise of interpretation explained in Gaydon does not depend on demonstrating that the legislator, whether Parliament or a minister exercising his powers under Section 2, positively intended the specific result in question. Rather, the legislative intent is presumed to be to give effect to EU law or convention rights, as the case may be, unless the terms of the legislation are such as to render that presumption impossible. That's the high threshold at which which Parliament had in mind by way of Section 3. And then just finally on authority on the scope of construction, tab 33, Rostock and Jessamy. In which this court was faced by the stark reading of Section 1087 of the Equality Act. It shall not be a contravention of this section insofar as there's post-employment victimisation. Nonetheless, the court read the Equality Act as a whole to say the very opposite, because that is what Parliament intended by way of Section 3, or in that case, Mar Leasing. And paragraph 41 which sets out the principles in relation to Vodafone and Gaydon. Paragraph 41 and 42 distills the authority neatly.
The head note says they regarded the failure of the 2010 Act to proscribe post-termination victimisation as an inadvertent drafting error. Can't really say that in this case, can you?
Well,
when did the inadvertent drafting error occur?
well, in Jessamy, there were two routes that got to the same destination.
Yeah.
And the first route was the Marr-Leasing point. Even if the Parliament positively intended that which is said in 1087, it still was not a fundamental feature of the legislation, etc. There's a further authority of Blackwood, where Parliament, Lord Justice Underhill, positively proceeded on the assumption that Parliament intended to do that which the claimant urged against. But nonetheless, that was not a fundamental feature of the legislation, and it did not preclude a Marr-Leasing approach. And the extent of the interpretive obligation has been consistently regarded as wide, even where it seeks to dilute the very words Parliament has used. So in Gillam, abundantly clear, the gateway for employment rights under the Employment Rights Act is the existence of a contract. The Supreme Court found there is no contract between a judge and the Ministry of Justice or anyone else. Doesn't matter, because the extent of the interpretative obligation is so wide that it was not impossible to read the Employment Rights Act as extending to judges. It was not a cardinal feature to exclude judges, whilst judges could have been deemed within the scope by way of positive legislation. That the failure to do so was not a fundamental feature of the legislation. In fact, those examples where a convention-compliant construction is not possible are rare. Ben Carboose, the State Immunity Act, does what it says on the tin, for want of a better phrase, which is you can't bring claims against states. Pytel, of which my lady is of course aware, the Utilities Act, blanket prohibition on the disclosure of documentation. Nothing that the tribunal could do in relation to that. The purpose of the legislation was to do precisely that which countered the claimant's case. What's the purpose of the Equality Act? To provide full and effective protection for discrimination. How does the availability of interim relief undermine that? It doesn't. It goes with the grain rather than going against it. Now, the wording that was suggested, the one point that is made by Mr. Justice Underhill in Coleman is that the drafting is not of the essence. The wording that was suggested before the EAT is at paragraph 135, page 260. Essentially incorporating by reference sections 128 to 132 of the Employment Rights Act. Incidentally, that is precisely the way in which it's done in the ancillary regulations relating to study or training. It simply says, please see sections 128 to 132 of the ERA, and that applies for the dismissal of these grounds. And if you need to see a copy of that, or at least for your note, it is tab 8. No, forgive me. Tab 10, section 18.5, or regulation 18.5, Sections 128 to 132 of the 96 Act, interim relief apply in relation to dismissal for the reasons specified in paragraph 3A or B. And we say it can't be regarded as a fundamental feature of the legislation not to extend that protection. It was not on the mind of Parliament. The fact that there were missed opportunities does not mean that the absence of that protection is a fundamental feature of the legislation. The fact that it is in potentially sensitive policy areas, well, which was a point which persuaded Mr. Justice Cavanagh, altogether less contentious than those authorities addressed at paragraph 47 of my skeleton, page 37, governing electoral law, protection of witnesses in sexual offences trials. And so, conscious of the time, I'll turn very briefly to the points that made against the construction that we urge. If this court concludes that an alternative is preferential, we're not wedded to it, but Mr. Justice Cavanagh regarded it as neat and elegant as a solution, paragraph 136 of his judgment. The first point that's made is that this undermines parity across the Equality Act because one guise of discrimination is treated differently. That ignores the whole suite of circumstances in which different guises of discrimination are already treated differently. Direct age discrimination is capable of justification. Equal pay claims can be pursued in the civil courts as well as the tribunal. No comparator is required for pregnancy claim. There are discrete claims in relation to disability, Section 15 discrimination arising, failure to make reasonable adjustments. There are specific exemptions for the purposes of the genuine occupational requirement defence. So the consistency point doesn't sit comfortably with the content of the Act itself. And of course, Parliament did see fit to identify dismissal as a specific detriment on the face of Section 39. We have no sense yet as to why that was, if it wasn't recognised that there was a separate issue or potentially separate issues arising from dismissal. The second point it's made is that this could extend to workers. 2 points in response, briefly. For there to be a continuation of contract order, there needs to be a stable contract. And secondly, the claimant, and through her the Commission, only seek to remedy the Convention discrimination, the Article 14 discrimination. If this court were to conclude that the true comparator or the true analogous situation is the employee who's dismissed on discriminatory grounds, then this court is not required to extend the right to workers. And indeed, the purpose of...
Yeah, but that would be the next case.
Well...
Wouldn't it? I mean, if it's right that an employee making a claim that she's been dismissed, in this case constructively dismissed or actually dismissed on discriminatory grounds, must have the, as it were, the statute interpreted or amended in her favour to allow interim relief, then, although we're not considering Limb B workers in this case, the next case will be why is there unjustified discrimination as between somebody in Mrs. Steer's position and a Limb B worker in the same position?
Well, the answer to that is, of course, you'd have to establish Article 14 discrimination in the first place. And in Adiatu, the whole question of whether Limb B was capable of being a status, that was conceded. But the other point that was made is that that is at the very outer edges of the concentric circles of Lord Walker's, that Lord Walker envisaged in RJM. Why, I mean, in many respects, the question answers itself. Why does an ad hoc self-employed worker not benefit from interim relief well, how do you get reinstatement, re-engagement, or a continuation of a contract if your status is as fragile as being a Limb B worker? And in any event, the basis of discrimination is, as I say, at the very outer edges and very easy, very capable of being justified. In any event, the true comparative for present purposes is the individual dismissed on the grounds of their sex or resisting sexual harassment, Mrs. Steer, and the whistleblower.
Yes.
Questions as to intolerable burden, costs, etc. I'm conscious of time, and I won't.
Well, we can't really evaluate that, can we? There will be cases in which interim relief is granted, but it shouldn't have been, and the employer will have to pick up the tab. We don't know how often that will occur. There would certainly be cases in which the employer says, I may as well concede the claim because I'll have to pay £25,000 in wages between now and the hearing, win, lose or draw. Now, that may be a good thing, it may be a bad thing, it depends which side you're looking at it from. But we can't really evaluate that, can we?
I can see the point. I think the only point I would add in reply is, of course, that applies to the regime as it already is in relation to whistleblowing, or for that matter, any other reason.
Yeah.
It's not a reason not to extend interim relief, because, of course, the very point of all employment legislation is recognised in unison, but particularly in relation to interim relief orders, is to redress the imbalance of power.
Yes.
And why should that imbalance be enjoyed by the discriminatory employer any more than the employer who dismisses on the grounds of whistleblowing? In short, these are not fundamental features of the legislation. Given the broad scope of the Section 3 power, it is not in the territory of that which is impossible. And any floodgates argument should be given a certain degree of caution, particularly where my learned friend submissions conclude, as they do, page 53.4, paragraph 53.4, page 71. The fact that at this stage it's not possible to know precisely how serious the practical repercussions will be only serves to reinforce this submission. It would be inappropriate for the court to jump into the void. Well, it's essentially saying we don't know, therefore you can't. And given the trajectory of discrimination claims on the Secretary of State's own figures, i.e. significant reductions over the course of the years that they cover, and the absence of any real clarity on floodgates, a floodgates argument, particularly in this context, is not a reason to fall short of all that Section 3 requires. In short, we say there is unjustified Article 14 discrimination. Section 3 reading is possible and therefore must be achieved. And whilst we're not wedded to the proposal, but before the EAT, the cross-referral makes it clear that the aim and the objective of any construction is to achieve parity with the truly analogous situation. My lady, my lords, I'm grateful for a little bit of indulgence and time, but unless there's anything further.
Thank you very much, Mr. Milson. You've been very helpful and very patient too. Mr. Purchase.
So if you'll excuse me, I'm just going to move myself across so that I'm not behind my lord's screen. My lords, my lady, can I start just by setting out 5 broad points which really in one sense form the backbone of the Secretary of State's position on this issue and arise in a number of contexts. In the analysis, The first is that employment rights and remedies have developed gradually over time. There is no single suite of employment tribunal remedies. On the contrary, each type of claim has its own tailored set of remedies attached to it. And in the context of this case, those remedies have been tailored by Parliament in primary legislation. And the two particular statutes with which we are concerned here, the Equality Act 2010 and the Employment Rights Act 1996, are very complex, interlocking edifices of rights, remedies and processes. My second point is that against that background, a right to claim interim relief is very much the exception rather than the rule. It arises only in a very small number of automatically unfair dismissal claims. And those claims all have something in common, which does not apply to other claims. And that is this: they all concern dismissal because of actions undertaken by individuals in pursuit of statutory rights, this is important, which have a collective or representative colour to them. So, the trade union representatives case is the most obvious one. There are other examples involving employees who represent fellow workers at disciplinary meetings and so on. Whistleblowing is another example, because everybody who whistleblows within the meaning of the 1996 Act, by definition must do so in the reasonable belief that it is in the public interest. And if you'll forgive me for just pausing there, just to deal with a point raised by my learned friend, it was in my submission very clearly always Parliament's intention that whistleblowing should be public interest disclosures, even though he is right to say that that language was only expressly inserted into the Act in 2013. And to make good on that point, I'll just make two references, if I may. The first is that the legislation which introduced whistleblowing was called the Public Interest Disclosure Act. Yeah. But secondly, the point is dealt with squarely in the Chesterton judgment to which my learned friend took you. That is behind tab 41 in the bundle, and I would refer specifically to paragraphs 12 and 13. Forgive me, 12 will be sufficient. It's on page 901. The inclusion in section 43B of a reference to the public interest was intended to restore the original intention of the Act. And then there are various citations from parliamentary debates to make good on that point. And a significant one is at the very bottom of the page. As the bill's sponsor, Lord Warby, said in the House of Lords, as I hope I have made clear, this measure will encourage people to recognise and identify with the wider public interest and not just their own private position. And that does, in my submission, amount to, for present purposes, a very important distinction between the types of claims which are covered by the interim relief provisions and the Equality Act claims. And that is not any sort of analysis as to which is more important in a general sense. The Secretary of State would like me to make clear, which I hope won't be surprising, that she takes discrimination very seriously indeed. That is why there is such a comprehensive and generous legislative scheme to protect against it. But what interim relief is designed to cover is cases where people are adversely affected by things that they have actually done for the benefit of others. And one reason why that started was, of course, the fact that such conduct is much more likely, or was much more likely, to lead to industrial action. The document, which I believe my Lord Justice Bean handed down this morning, makes good on that point. It's a point which was recognised by the Northern Ireland Court of Appeal in the Bombardier and McConnell case, which is cited in my scale as an argument. But there is, in short, a coherence and a very reasonable and understandable coherence in my submission to the sorts of claims which are covered, as opposed to those which are not. My third point is that, looked at holistically, the remedies available in discrimination claims and the processes applicable in discrimination claims are different in a general sense from those applicable in automatically unfair dismissal claims. Some of the features of the two schemes are more favourable in one direction, some are more favourable in the other direction. And just pausing there, that remains the case, even if you take into account my learned friend's argument that you must proceed on the basis that whistleblowers can claim both for detriment and for dismissal under Part 10 of the Act. I'll deal with that in a little more detail as I move through my submissions, but just to take a couple of examples, it remains the case that the approach to time limits is much more favourable in the discrimination legislation. You have to bring a claim for whistleblowing detriment within 3 months, and you can only get an extension of time if it was not reasonably practicable to have brought it within 3 months. In discrimination claims, you can get an extension of time on a much broader basis, but it's just inequitable to do so. And in some cases, that has led to extensions of times of many, many years. That's one example. There are a number of others, and I will come to them in due course. My fourth point is this, and that it is that the choice of which remedies ought to be available in this context is a political and social question, and it is a political and social question which has economic consequences. It has economic consequences for employers, for employees, and for the public purse, in the sense that it engages the employment tribunal system. And I would submit that that political and social element of the analysis is particularly so in respect of interim relief, given the sort of reasons for which that was introduced. And answering that political and social question involves balancing a number of different interests and consequences, or potential consequences. Some of those interests are interests between private parties. So the range of remedies available clearly involves involves balancing the interests of employees on the one hand and employers on the other hand. But in the context of interim relief, it also involves balancing the interests of claimants who can claim it, or who do claim it, and claimants who don't. Because by definition, the more claimants who claim interim relief, the longer it's going to take for the employment tribunals to get round to dealing with claims from claimants whose claims do not attract that remedy and therefore have to be pushed back down the system. It's also a question of balancing private interests against public interests, because the more interim relief claims there are, the greater the burden on the employment tribunal. And there is, because of the impact on employers, also an impact on the economy. Those were, the idea that this is really a political and social question was, I should observe, accepted by the Employment Appeal Tribunal in this case, at paragraph 188 of its judgment. That's at page 280 in the core bundle. My final and fifth point is that the Equality Act 2010 was, on any analysis, clearly the product of an especially full and careful consideration. And that consideration involved a desire, on the one hand, to achieve consistency and simplicity so far as possible within the Act. But it also expressly involved balancing the sorts of interests which I discussed in the previous point. And could I just ask the court to turn firstly to the explanatory notes to the Act, which are behind tab 9 in the bundle of authorities. And then in particular, could I just ask perhaps the court to read to itself paragraph 7 to 11.
No draft bill as such, but several consultation papers.
Yes,
is that right?
there were a significant number of consultation papers, some of which are before the court. I'll turn to one of those in a moment, but could I just draw attention to one point in paragraph 12 as well, which provides that the Act strengthens the law in a number of areas, and then over the page is a series of bullet points, and the third one up from the bottom of that paragraph says that it enables an employment tribunal to make a recommendation to a respondent who has lost a discrimination claim to take certain steps to remedy matters, not just for the benefit of the individual claimant, but also the wider workforce. And that's important because it shows that the drafters of the legislation and through them, Parliament, did address its mind to whether it was necessary and appropriate to extend the remedies available under the Equality Act. And they decided to do so to that extent. The consultation document is in the core bundle at page 94. Starts, just for your note, at page 83. It's the Discrimination Law Review Proposals for a Single Equality Bill for Great Britain consultation paper. And what that page does is show the intention, firstly, to simplify the law, but secondly, to balance various considerations and interests. firstly, at the second paragraph on page 94, the Discrimination Law Review has been informed by extensive research and discussions with key stakeholders. The document sets out for consultation our proposals for building on the advances we've already made towards a fairer society by creating a clearer and more streamlined legal framework for equality. In developing our proposals, we have balanced the desire for consistency with the recognition that approaches need to be appropriate to the particular experiences of those facing discrimination and proportionate to the size of the problem. And then under the heading simplifying the law, because the law has developed over more than 40 years, different approaches have been taken at different times. And the law is set out in many different places, in Acts of Parliament, regulations and orders. There is a widespread agreement that everybody who needs to understand discrimination law will benefit from having it in a single Equality Act which simplifies the law as far as this can be done. But rather than just consolidating the current legislation, we want to take this opportunity to review it and decide whether we can improve it to make it fit for the 21st century. At the same time, we want to make sure that it provides the necessary protection against real unfairness while taking a proportionate approach to the regulatory burdens this necessarily imposes on private, public and voluntary sector businesses, authorities and organisations. So just pausing there, my Lord Justice Bean is right to say that I'm not able to point to any specific express consideration of interim relief in the development of the Equality Act. But what in my submission is unarguable is that Parliament can be taken to have accepted the view that the Equality Act as it is struck the right balance between those various interests of promoting fairness for individuals on the one hand and not placing a disproportionate burden on others on the other hand. And as my lords and my lady knows, it is part of my submission that pulling out one aspect of that carefully balanced regime, or rather importing one aspect into that carefully balanced regime, runs a serious risk of disturbing the balance, both within the Equality Act itself, but also between the Equality Act on the one hand and the Employment Rights Act on the other. So those are my introductory points, and what I propose to do now is simply move directly into the heart of the grounds and deal with them in the same order that my learned friend did.
Yes.
So the first issue is whether this complaint falls within the ambit of a substantive convention right. Because if it does not fall within the ambit of a substantive convention right, Article 14 does not come into play at all. My essential point in relation to Article 6 and Article 1 of Protocol 1 is reliant on the correct analysis of legal remedies as understood by those convention rights. My learned friend's position is that a remedy, including interim relief, is, as he put it, a matter of procedure. It's basically a process by which you enforce an underlying right. My submission is that a remedy, particularly a remedy as significant as interim relief, is a matter of substantive law, which is and ought to be treated as part and parcel of the actual civil right in question. To put it another way, the remedies that you are able to obtain define, to some extent, the scope of your actual rights. They aren't merely procedural add-ons. They are at the heart of the matter. Moving on then to how that applies in the Article 6 context, could I just take your lordships back and your ladyship back to the article itself. You'll be familiar with it, but it's worth looking at exactly what it says. It's behind tab 5 in the authorities bundle at page 660. So sorry. 66, not 660. And what it says is that in the determination of his civil rights and obligations, or of any criminal charge against him, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. So what the article is about is how and when your civil rights are to be determined. It is not about the content of those rights. It is not concerned with substantive law. And that point was made clear by the House of Lords in the Matthews against Ministry of Justice case, which is behind tab 17 in the bundle. And I'd like to take the court to paragraph 121 firstly. That's at page 310. And in that paragraph, Lord Walker cites the first sentence of the article and then goes on to say, on the one hand, the composite rights conferred by Article 6.1 necessarily involve a right of access to the court. And then he goes on to look at that in a little more detail. And then just between letters G and H, he says, on the other hand, a litigant's right of access to the court for the determination of his civil rights does not guarantee any particular content of those rights. And that sentence encapsulates 2 points. The first that I laboured a little just now, which is that the right of access to the court is for the determination of your rights. And the second is that the article is simply not concerned with what those rights are. The second paragraph is paragraph 142, which starts at page 316. And there Lord Walker says, although there are difficulties in defining the borderline between substance and procedure, the general nature of the distinction is clear in principle. And it is also clear that Article 6 is in principle concerned with the procedural fairness and integrity of a state's judicial system, not with the substantive content of its national law. And it is quite clear in my submission that that defines the ambit of Article 6 for Article 14 purposes as well. And to make good on what in my submission is an obvious point, can I take you to the Court of Human Rights judgment in Roche against the United Kingdom? That's behind tab 61 in the bundle of authorities. And to paragraph, sorry.
At paragraph.
Paragraph 119.
Yes.
The court there refers to an earlier judgment in the Fayed case. and it points out 2 lines up from the bottom, that case does not affect the scope of Article 6 of the Convention, which can, in principle, have no application to substantive limitations on the right existing under domestic law. And if you'll forgive me, since we're in this authority, for just deviating for a moment into Article 1 of Protocol 1, at paragraph 129, the European Court of Human Rights dealt with the argument that the right to a claim in negligence amounted to a possession for Article 1 of Protocol 1 purposes, and said this: the court recalls that a proprietary interest in the nature of a claim can only be regarded as a possession where it has a sufficient basis in national law, including settled case law of the domestic courts confirming it. The applicant argued that he had a possession on the same grounds that he maintained he had a civil right within the meaning of Article 6.1 for the reasons outlined under Article 6.1 above. The court considers there was no basis in domestic law for any such claim. The applicant had no possession within the meaning of Article 1 of Protocol number 1, and the guarantees of that provision do not therefore apply. And then over the page, at page 133, in light of its findings that the applicant had no civil right or possession within the meaning of Article 6.1 and Article 1 of Protocol 1, so that neither article was applicable, the court considers that Article 14 is equally, therefore, inapplicable. So, in my submission, where the complaint is about the absence of a right to claim interim relief, that is a complaint about the scope of the rights conferred by substantive domestic law, and it therefore simply falls outside the scope of both Article 6 and Article 1 of Protocol 1. I would at that point just like to take your lordships to citations where certainly senior judges appear to have proceeded on the basis that the nature of the remedy available is indeed properly to be treated as part and parcel of what the right is. It is, in my submission, an obvious point of principle, but starting back, if I may, with the Matthews case, which was behind tab 17 in the authorities binder. In the judgment of Lord Bingham, paragraph 15, the way his lordship expresses himself on the Article 6 issue is that I consider it to be clear that Parliament did not intend to confer any substantive right to claim damages against the Crown for the exempted claims. Now, it's right to say that the point I'm making was not a point which was in dispute in that case. But in my submission, it is telling that Lord Bingham just automatically assumed that the scope of the remedy was an inherent part of the substantive right. He also quotes a judgment of the European Commission on Human Rights, which took the same approach, and that you can find at paragraph 16. And 5 lines down, Lord Bingham refers to Pinder against the United Kingdom, which concerned section 10. The Commission posed the question whether there can be said to be a civil right where such a right, i.e. a right to compensation, for negligence has been expressly removed by a statutory immunity such as that conferred by Section 10 of the 1947 Act. And then the final authority on this point is the judgment of the European Court in the HEO case. That's behind tab 62. And this was a case concerning the failure of making child support payments which had been assessed by the Child Support Agency. And can I ask you to turn to paragraph 46? In the present case, it said the applicant argued that she had a civil right to the enforcement of maintenance assessments made by the CSA in respect of Mr. K, and that she was denied effective access to the court to secure such enforcement or to seek redress for delays on the part of the CSA in enforcing maintenance payments. The government contended that under the scheme introduced by the Child Support Act 1991, the applicant enjoyed no such right, and that the remedy of judicial review provided her with an effective means of vindicating her complaints of delay in the enforcement process. The court does not find it necessary to resolve the dispute as to the existence of such a right, since even assuming that the applicant enjoyed such a right, the central question remains whether her effective access to the court was restricted or reduced in such a way that the very essence of the right was impaired. There then follows what is quite a dense paragraph, and before I leap into it, if I may just say what I submit the court is saying in that paragraph. What it is saying is that even assuming that the claimant had that right, it was met by her ability to seek injunctive relief by way of a claim for judicial review. The court goes on at the end of that paragraph to note that the claimant complains that she's not in addition able to get damages for a failure to enforce the child support payments, at which point the court says we're not concerned with that question because Article 6 does not concern the scope of substantive law. And what it is doing in my submission is saying the nature of the remedy that you can get is actually part of the substantive law in question, which does not fall within the scope of Article 6.
Have I got this right? What she said was, in a better organised world, I would be able to sue the father directly in the county court.
Yes.
The government prevents me from doing that, and I have to get judicial review against the Child Support Agency, which is slow, costly, and not terribly effective. And the Strasbourg court says, well, that's just too bad. That's not a... you have access to the courts. Is that...
Yes.
That's what
But what she says is, I have a right to the enforcement of the child. I have a right to get relief if the Child Support Agency fails properly to take enforcement action to get me my money. She says the relief I want is twofold. Firstly, I want them to do it, and secondly, I want damages. And the Court of Human Rights says, well, you can get them to do it because you have a right to claim judicial review. The fact that you can't get damages on top of that is not our concern because that's a matter of substantive law. And for those reasons, in my submission, a complaint about failure to be able to claim interim relief simply doesn't fall within the ambit of Article 6 at all. It's worth just noting a couple of additional points in response to arguments made by my learned friend. The first is that interim relief, of course, is not a means of getting access to a court for the determination of your discrimination claim. By definition, an interim relief application does not determine your discrimination claim. So it doesn't fall within the scope of Article 6 as being a means of determination of a civil right if the right is defined as the underlying claim in any event. On the contrary, it is a particular substantive remedy in its own right. And the second point is this, and that is that it is clear in my submission that interim relief was not designed as a means of enabling claimants to bring claims for the determination of their civil rights. I don't dispute, of course, that in practice, the fact that a claimant has a financial income from getting interim relief will assist her in being able to continue with her claim. But the purpose of the introduction of interim relief was clear in my submission. Initially, it was to prevent industrial unrest, and it is extended to protect people who have taken particular action in response to collective claims. It is not, by design, concerned with promoting access to the court. Moving on then to Article 8. My learned friend took the court to a number of authorities from the Strasbourg court. Happily, this court has already grappled with the vexed question of when and how Article 8 applies in dismissal cases in the Wandsworth Council against Vining case.
Oh, the park superintendents or parks constables.
That's right, my lord, yes. So that's behind tab 40, and my lord is right. The case concerned the exclusion from the right to claim unfair dismissal of parks police or parks constables, who were an unusual category of constables, who were in fact employed by local authorities to police parks rather than constables purely in the core sense of the word of holders of public office.
Which tab?
Tab 40.
No, it's not.
Vining.
It is in my bundle. Vining against London Borough.
Oh, right. It's
Wandsworth.
Ben Carbuck's in mine. What's the what comes before it?
Just before it is Stevenson against Secretary of State for Work and Pensions.
Right. Something.
So start
Anyway,
with
I
just
found
test
it.
it in case.
Yes. Right.
I think my bundle fell apart and I seem to have lost it altogether.
Yes. My compliments to whoever made up the bundles, but they were all so crammed that they had a tendency to explode. Right. So anyway, I've got Vining.
Oh, I've got it. It's tab 36. I have found it eventually.
Just give me a moment to do some housekeeping.
Yes, I think I must have put my bundle back together again. Incorrectly.
Vining, paragraph.
Paragraph 47, and I won't pick through the whole judgment, but my lord, the Court of Appeal cited and grappled with all of the authorities that my learned friend relied on before this court today. And then the conclusion it reached at paragraph 47 is that it's clear from the statement of principle in Martinez and the reasoning in that case, as well as the reasoning in all the cases on which Ms. Criddle relies, that the mere fact of termination of employment is not sufficient of itself to make Article 8 applicable. In paragraph 109 of Martinez, the Grand Chamber clearly stated that the Convention confers no general right to employment or to the continuation of employment. In none of the cases did the European Court say that Article 8 was engaged by the mere fact of dismissal, but rather it went on to consider whether the consequences of that particular dismissal made Article 8 applicable, and then cites a number of examples. So, the clear decision, in my respectful submission, binding decision of the Court of Appeal in that case, is that whether or not Article 8 applies to a dismissal will depend on the particular facts, and specifically the consequences of the dismissal for the individual employee. Moving back then to paragraph 42, if I may, you can see that what had happened in that case was that Miss Criddle, who was representing claimants, had in her skeleton argument set out a number of consequences which she said were sufficient to engage Article 8. And the Court of Appeal dealt with how that sort of approach should be treated in paragraph 48 of the judgment. Turning to the paragraph 5.16 consequences, we reject the argument of Mr. Capel that these should be disregarded because they are unsupported by any evidence. That argument ignores the reality of the way these proceedings have developed. The employees were acting in person before the tribunal at a time when the only issue was one of the proper interpretation of the domestic legislation. The application of the Convention only arose before the EAT after the decision of the Court of Appeal in Redbridge. The employees amended their answer to rely on the Convention in the paragraph 5.16 consequences. In other words, the claimants can be excused in that case for not having put those consequences before the tribunal. Then, in the last sentence, the Court of Appeal says, in the circumstances, if the paragraph 5.16 consequences are capable of engaging Article 8 or making Article 8 applicable for the purposes of Article 14, the right course would be to remit the case to the Employment Tribunal to make a decision on the employee's factual allegations. Again, to paraphrase that, contrary to what my learned friend suggests, it is clearly not appropriate in deciding whether or not there has in fact been a breach of Convention rights to proceed on the basis of the facts as alleged by the claimant. In order to get herself into the door of Article 14, she has to prove as a matter of fact that her particular dismissal fell within the ambit of Article 8 or, of course, Article 6 of Article 1 of Protocol 1, which I've already dealt with. As it happened, you can see from the start of paragraph 49 that the Court of Appeal took the view that the alleged consequences in that case were not even capable of engaging Article 8 or making Article 8 applicable for the purposes of Article 14. The position where that leaves us is that I'm bound to accept that it is possible that the claimant's dismissal in this case engaged Article 8. There hasn't been any attempt to set out the consequences of the dismissal on her, such as to potentially engage Article 8. And I don't think it would be appropriate on behalf of the Secretary of State for me to make any submissions as to what, if anything, this court should do in those circumstances. But what I can say on behalf of the Secretary of State is that the court is not in a position now to decide that this case falls within the scope of Article 8 at all. A possible approach that may be open, depending on the views of your lordships and ladyship, would be to look at the matter as a point of principle. But in my submission, it's certainly not the case that this claimant can establish a breach of convention rights based on Article 8.
Mr. Milson doesn't seek to say that all unfair dismissals engage Article 8. He seeks to say that discriminatory ones do. I don't see much to help in the answer to that question from Vining, which is about a lot of things, but not discrimination. It doesn't seem that 4789 seems to say not every dismissal case engages Article 8. See paragraph 47. But they don't say, nor do you, that no dismissal case can ever engage Article 8. Do we get any help from this case as to whether Mr. Milson's argument is of general application in sex discrimination case?
Well, you do to this extent, my lord. If you turn back in the Vining judgment to paragraphs 34 and 35, we can see that the Court of Appeal refers there to the Boyraz case, to which Mr. Milson took this court earlier this afternoon. That was the dismissal on the sole ground of sex case.
Yes.
And then at paragraph 47, at precisely the point at which I stopped reading the paragraph, where the parentheses start the end of paragraph 47, after having said that Article 8 is not engaged with the mere fact of dismissal, but rather went on to consider whether the consequences of that particular dismissal made Article 8 applicable, 4 or 5 lines down it refers back to Boyraz and says in Boyraz the effect on the applicant's identity, self-perception and self-respect. And in my submission, the only proper reading of that is that the court is not accepting that a discriminatory dismissal will always engage Article 8. It depends very much on the effect on the applicant. And in my submission, that is so, whatever the form of dismissal. But it is, of course, just worth pausing here to observe that there are lots of different sorts of discrimination. And they include, for example, things like indirect discrimination and a dismissal which may be indirectly discriminatory. It is perhaps unlikely, one might think, to have the same sort of impacts on an individual as one which is directly discriminatory. To take a random example, for example, an employer might go through a redundancy process, perfectly legitimate, genuine redundancy process, and apply a selection criterion based on the number of days sickness that employees who were up for redundancy had. Again, perfectly genuine, perfectly honest, and on the face of it, perfectly sensible. But it may be that there is a disabled employee within that pool who, because of his or her disability, had a particularly high level of sickness absence. And they may say that that was an unjustified provision, criterion, or practice which put them at a disadvantage. It's difficult in my submission to see how that sort of discrimination would engage Article 8. So in my submission, it would be not appropriate to proceed on the basis that discrimination claims will always engage Article 8.
folks, just when you get to the end of a topic, we probably ought to break off, but I'm not saying
I was
it has
just
to be
gonna-
this moment.
I'm so sorry, but I was
Yeah.
just going to suggest that exact
Right,
thing, actually, because I'm moving on to status.
right.
now, so,
Yes, so you've got status, analogous situation, justification and remedy.
yes.
Can you estimate how long that'll be?
An hour and a half, I think. I'm just trying to work out how long that's going to leave for.
Well, we'll see. We'll see how we go. We mustn't truncate this. It's an important case. Right, 10:30 tomorrow.